Good afternoon. Happy Sunday. The post I made about Earl filing his new little suit, people seem to be misunderstanding. I do think it's not wrong, but it's odd to write improper person. The Latin is impropria persona. So if you want to be formal, you write impropria persona. If you want to be informal, you write improper. Or, as they like to do in federal courts, usually in federal courts, they call it pro se. Now, I don't think a court is going to misunderstand that Earl is representing himself. I don't think it's a defect in his pleading. I just thought it was odd. But my point in making the post was that Earl was once again representing himself. Now, I don't know how long your memories are, but Earl recently, maybe a year ago now, filed a federal lawsuit. He filed a federal lawsuit against me, Teresa Richard, Felipe Hemming, Krista Hemming, the Hemming Firm, LLC, which doesn't exist, John Masters, God, what's Texas Wolfman's name? I forget. I'm sorry. Anyway, bunch of people. He filed it against Google. Anyway, the initial problem with, well, there was a lot of problems. There were a lot of problems with his initial complaint. And I don't want to go into all of them, but there were a lot of problems with it. But his big problems were, number one, he didn't serve everybody that he named in the complaint. And what that did is, since he didn't do it, and since the court gave him additional time to do it, and he still didn't do it, so the court dismissed those people. That's how I got out so scot-free and easy, is because Earl was too lazy and or incompetent to serve me. Serve process. I mean, it's not that hard to do. Then, a couple of the plaintiffs who were still in, the defendants who were still in, filed motions to dismiss. And they were supposed to meet and confer. I don't think they really did, but the court said, you need to correct your pleading, apparently, if I remember correctly. And take all this with a grain of salt. I haven't looked at this in a long time, so, I mean, I could be wrong on some of it. But anyway, after telling him that he needed to amend his complaint and then serve it on the defendants who were still in the lawsuit, Earl didn't do it. And the court gave him like an extra month or two. Earl didn't do it. And so the court dismissed his case. So when I loll over Earl filing a lawsuit pro per, I am lolling because Earl's filing a lawsuit pro per. That's the joke. That's the joke. Earl's got a lot of problems with his complaint. I don't think his complaint in this case against Leon Valley, Joe Salvaggio, and the other Salvaggio's cartoon cops. What are the Keystone Cops? That's what I meant to say, Keystone Cops. Anyway, I don't think it's going to survive a motion to dismiss. I'm not talking about a assertion of qualified immunity. I'm just talking about a straight, flat-up motion to dismiss. Because for those of you who don't know, 42 U.S.C. 1983 does not have a statutorily prescribed statute of limitations, which means there is no single statute of limitations for a 1983 lawsuit. Supreme Court decided, I'm going to screw the name up. I'll throw it out there. Owens v. Okura? Okura? Whatever. Something like that. The Supreme Court finally addressed it because there was a split in the way various circuits were handling it. And the Supreme Court said the statute of limitations is the same as whatever state the injury happened in. It's the same as that state's personal injury law. So Earl had his rights violated in Texas, and so you use Texas's personal injury statute of limitations. Now, for questions surrounding it, my best understanding is that you use the way the state would handle a case against the cops. You use that. So Earl tries to get around the statute of limitations problem by pleading that his equipment wasn't returned until May 4th. And the continuing tort theory is what he thinks does it. I don't believe so. The injury accrues when the item is returned, not when the injury accrues when the item is taken, not when the item is returned. And so the seizure of the camera, etc., accrued when it was taken from him, not when it was returned to him. So I think he has some real serious problems. Now, he needs an attorney. He needs an attorney because, like I said, either he's lazy or incompetent or both. And there's going to be motions to dismiss. There's going to be assertions of qualified immunity. And he's going to need to have someone who has a good grasp of the law to represent him, to get past those hurdles. You know, you can get by on a fairly lenient or a fairly threadbare complaint. You don't need to know a lot about the laws. You just need to say what they did to you and that it hurt you. Beyond that, you're going to need an attorney, because you know that Salvaggio is going to have an attorney. You know Leon Valley's going to have an attorney. You know all the other cops that are being sued are going to have attorneys. And those cops, or their attorneys, excuse me, the cops probably don't, but their attorneys are going to understand the law. And if they don't understand the law, they're going to take the time to look it up and make sure they understand the law. And then they're going to write memorandums, briefs, telling the court why exactly Earl should go F himself and not get a penny. He needs an attorney. He's just not capable of doing this. I don't care what form he filled out that to write up that complaint, who he copied it from or how. That doesn't matter. That just starts the ball rolling. That doesn't get you across home plate. And to be fair, well, to be honest, I don't know. Full disclosure, I'm not really pro Earl in this. I don't have any love for Earl. My stake in this, the reason why I have suggested to Earl through WTT that Earl get a lawyer, is because I don't like bad cops. And Salvaggio was flat out wrong to arrest the protesters. He was flat out wrong to seize their recording equipment and their cameras and all the other things that he seized. He was bad. He was wrong. He needs to be punished for that. And I hope it costs him a lot of money. But Earl throwing away, you get one shot. Just so everybody's clear. You get one shot basically you got to file all your claims against the bad guy, revolving it around that same nexus of facts at one time. So you can't file a federal cause of action today, have that get blown out, go back, find a state cause of action for the same injury, and file that and hope that works. Because it's res judicata at that point. It's done. You get one time up at bat. So, I mean, he needs to get an attorney. That's all I'm saying. He needs to get an attorney if he wants to if he wants to get any semblance of justice. And again, for those of you who aren't paying attention, we have a legal system, not a justice system. But if he wants to get any semblance of justice out of our legal system, he's going to need an attorney. He's just going to. So if he doesn't get an attorney, I'm going to put this up at around a 95% chance that it gets dismissed. If not at the just a summary, request or a motion for dismissal. But if not then, or if they combine it with a assertion of qualified immunity, it's 95% that it's going to get dismissed. It's going to get tossed. So he needs to get an attorney, and maybe there's some state cause of action that's going to save him. Maybe because there may be state causes of action, and there may be state causes of action that told the statute of or not cause of action, but there may be state, like for example, during COVID, California told the statute of limitations on all new causes of action for I think a grand total of about 6 months, give or take. I don't remember exactly. But during COVID, the statute of limitations was told. If Texas told the statute of limitations for 2 years, then hey, maybe but he needs to find an attorney. That's all I'm saying. And maybe the attorney can find a state cause of action. You don't always have to sue under 1983. There are other causes of action out there, maybe in state law, maybe in federal, but get an attorney. Thanks for watching. Have a great day.